and gets this bill
has
through.
expired. The question now is that the amendment be disagreed to, and I give the call to the member for Hughes.
Thank you, Madam Deputy Speaker. We're all equal before the law. Well, that's what we are taught at school, and in fact that is even a provision of the Universal Declaration of Human Rights. Article 7 states, and I quote, "We are all equal before the law and entitled to equal protection." But the reality is, in Australia today, because of the obscene and the prohibitive cost of justice, our legal system is broken and we are not all equal before the law. Where a small business has a commercial dispute against a large foreign multinational, that small business's chance of resolving that dispute through our court system is in fact almost next to zero. The large multinational company can simply laugh at that small business and say, "How are you going to possibly afford the legal costs?" And even if you win at first instance, we'll appeal it. We will delay the procedures, we will bleed you dry. And when that occurs, we are not all equal before the law. Look at the costs of the former Attorney General's legal proceedings against the ABC in his defamation case. The plaintiff, his costs were estimated at somewhere around $1 million. The ABC have acknowledged that their costs were at least $800,000. And that case never even made it to a courtroom. What do people think, working in the real world, out in the western suburbs of Sydney and Melbourne, adding value to the economy by making things and growing things and producing things? How can they possibly look at it that completely unproductive work that does nothing to benefit the overall economy, such as that defamation case, has close to $2 million in legal costs and yet never even gets to the courtroom? That's just a mediation. People that are involved in family law disputes look at the cost of the actions and just see themselves being bled dry by a system. The reality is, as much as we don't like it, that class actions are the only things that provide many small businesses, many small plaintiffs, the only opportunity to seek justice before the courts. And yes, these litigation funders are sharks. Yes, in many cases, I'm sure they have ripped people off. But a form of price fixing, setting a maximum of 30% that the litigation funder can obtain for his costs, is not the answer. That is trying to fix the symptom, not the cause of the problem. Now, by going down this track, by putting that 30% cap on, Madam Deputy Speaker, all that will happen, it won't result in greater returns for small plaintiffs. All it will do is change the risk-reward calculation for these large litigation funders, because they are in fact gambling. They'll weigh up the odds of the merits of the case. They'll weigh up the odds of the potential of winning. They'll weigh up the odds of how aggressively the defendant will defend the case. And they put that in and they think that they can make a great windfall profits, they'll proceed with the case. But if you change those parameters, if you limit it to 30%, you change that risk-reward benefit for them, and the only result will be is that more Australians more individuals, small businesses, will have less access to the courts than they already have. And that is something I cannot support. Madam Deputy Speaker, I think I'm one of the few people in this place that has ever had to try and put together a class action for a group of small businesses. It was involving extraordinary container detention fees charged by large foreign multinational shipping lines, many of them controlled directly by the Chinese Communist Party. We had a good case. We won on first instance. But because it was a slightly grey area of law, when we took it to the class action funders, they looked at it closely, but they admitted it was just slight doubt and therefore they wouldn't fund it. Changing the parameters, limiting the amount that they could get, the class action funders, even though it seems like a right idea to do, will punish the very people that this legislation says it protects. And what class actions do we have on the horizon, Madam Deputy Speaker? We know that already 10,000 Australians plan to claim damages for COVID vaccine injuries under the government's no default scheme. Madam Deputy Speaker, but how many more will it be and what case will they have? The lawyer for Shine Lawyers is quoted, "Some of these reactions have been clots, major strokes, amputations, major cardiac problems, being on oxygen, having severe headaches that are debilitating and being unable to work." Now, at the moment, there's a cap of $20,000. How $20,000 compensates someone that has their leg amputated, Madam Deputy Speaker, I do not know. And my great concern is that we're going to see more of these class actions involving the TGA. And as many other members of Parliament have given examples of potential class actions, I would also like to give one. Now, the TGA data reports that the adverse events from the COVID vaccines is 0.21%, or 2.1 in every 1,000. But the problem is, the question is, how accurate is that data? Now, there's another group that reports on adverse reactions, and that is a group called AusVac Safety. Now, where the TGA relies on a system of people voluntarily reporting to them, AusVac Safety, on the third day after someone has their COVID vaccine, sends out a text message and requests the information. As at the 14th of November, they've sent out over 4.6 million text messages and had surveys completed. They have found that 43.8% of people had reported one adverse event, and 0.9% of people had reported visiting a GP or an emergency department. Now, how is it possible that the TGA data says there's 2.1 adverse reactions reported to it per 1,000, and yet AusVac Safety is reporting 90 per 1,000? So again, TGA 2.1.
Order. The member will address his remarks to the bill, please.
Madam Deputy Speaker, I'm setting out the potential class actions, examples of class actions, as many other people have done here, many other members have done during this debate, Madam Deputy Speaker. I think it's important that, as the government, we understand what the potential of these class actions are and how this bill will actually shut the route of Australians seeking justice and seeking compensation. Because we have the TGA, I believe, has set this government up for many claims of class actions because they are using a system of reporting that is unfit for purpose and is missing many of the adverse reactions. Madam Deputy Speaker, the question is how many cases or how many class actions will be knocked out because of this potential legislation. Published in The Australian a few days ago, a report that stated PwC found that more than 90% of cases, that's class action cases, may not have gone ahead because the funders and lawyers would have been left with either a loss or an inadequate return to justify the risks of taking on a long and complex case with uncertain outcomes against a well-resourced defendant. And the article goes on. The government's proposals would have denied justice to hundreds of thousands of Australians who have turned to class actions to help rebuild their lives. Madam Deputy, I don't know whether that 90% is correct of class actions that wouldn't have gone ahead. But I do know that this legislation would change that risk-reward balance and result in less class actions going ahead and result in less Australians having access to justice. And of course, the cases that are potential. We only have to look at the one example where there is a potential class action that Australians may wish to sign up to, is the TGA's approval of the Moderna vaccine for 12 to 17-year-olds. Now, even though that is made in the USA, it does not have approval in the USA for 12 to 17-year-olds. It does not have approval in Germany for 12 to 17-year-olds. It does not have approval in France for 12 to 17-year-olds. Nor Sweden, nor Denmark, nor Finland, nor Norway. But yet, here in Australia, our TGA has decided that the Moderna vaccine can be injected in 12-year-old Australian children. Now, one only has to look at the recent data, again, from AusVac Safety to say what a potential great risk this is of future class actions. Now, what that data shows from AusVac Safety, it makes a comparison of the Pfizer and the Moderna vaccines of the impact on routine activities of children aged 12 to 15. From the Pfizer dose, after the second dose, there are reports of 22% of children missing work, study or routine activities. But when it comes to the Moderna, it is 39%. 39% of Australians aged 12 to 15 years after the second dose of Moderna are reporting either missing work, study or their routine duties. How can we allow this here in Australia? We have this data is publicly available, the TGA continues to close their eyes to it, they continue to ignore the fact that countries like Germany and France have suspended the Moderna vaccines in 12 to 17-year-olds, but yet they continue it in Australian children. The adverse reactions continue to mount, the potential legal cases continue to mount, and the potential for class actions continue to mount. Mr. Speaker, I cannot vote in favour of any legislation that further restricts Australians' access to the courts, that further restricts Australians, especially those small businesses, access to justice. And that is exactly what this legislation sadly does. To me, it is contrary to all the principles of when I signed up to the Liberal Party that I believed in. Equal rights and a fair go, an equal opportunity for small business, protection of the individual citizens, allowing the free market to work rather than through price caps. We are far better to have more firms in the area of class action and litigation funding rather than less. That is the way we bring the costs down, not through artificial Soviet-style price caps. That is not the way the Liberal Party goes about things, but that is the way, the mentality and ideology that they bring with this legislation. Therefore, I thank the House, but I will be voting against this legislation.